Good evening. Today we are going to see about the fixed term employment in appointments, how it works in India. In India, fixed term is an employment arrangement where an employer employs an employee for a specific period and this employment automatically comes to an end. So the period of an employment comes to an end and the specific JD to be defined and the where the person to be appointed, all these things will be defined under this contract. So we can engage a person for a specific period to work on time-bound project to cover the workman employee who is maternity leave of 26 weeks. So we know the female employee will go for a maternity leave for 26 weeks. Those period we can engage the fixed term employee people to cover the seasonal peak at work. We doesn't know. Uh, some of the times, that is in sugarcane industry and all, we engage the people during the season only. So those periods we can engage the fixed term employees. The fixed term employment is regulated by the Indian labor laws under ISO, Standing Order Act, and also ID Act, which are the two main federal laws that govern the working conditions of the workmen under the employees managerial, supervisorial and other positions. The model standing orders under the Standing Order Act standard documents setting out the terms and conditions of the employment in their standard form by amending without changing the substance, by amending the benefit to the employees. So here there is a format and the what is to be done, how it has to be taken off. All these things are available under the under the Standing Order Act. The fixed term employment, the definition adopted model standing order framed by the certain states including Karnataka and Haryana. For example, model standing order in Karnataka defined temporary workmen. Then that defines workmen have engaged for work which is essentially for temporary nature, like to be finished within the limited period under their Standing Order Act. And that is also given the importance in on 7th October 2016 fixed term employment in apparel industry, that is manufacturing sector under Industrial Standing Order Act. On 16th March 2019 again it has extended to other sectors in Punjab, Karnataka, Goa and Bihar. And what are all the types of fixed term employment may be structured? Fixed term employments, the employer themselves can preclude the terms of employment. Then they have to pay the retrenchment compensation and other benefits to an employee, that is to the fixed term employee. And the automatic cessation of service when the period concludes. So there are two types when the time of termination of employment under the fixed term. The fixed term employee must to an end and not continue to beyond the set period unless there is a pregnant reason for extension. If an employee engaged for a specific project and if such period gets extended for certain reasons, employer should have sufficient justification to employ the individual on fixed term employment as opposed to the ongoing employment relationship. Several Supreme Court cases. Examples: S.M. Nilashkar versus Telecom District Manager and District Manager Karnataka, and High Court cases, for example, Chief Administrator Haryana Urban Development Authority, Mani Majra versus Industrial Tribunal, have differentiated between the genuine and non-genuine cases of fixed time employment based on the factual situation in each cases. So in some of the employer may engage the people on fixed term, but they are shadow contract. There may be some of the shadow contracts which are also available, but it should not be. And as per the Indian Industrial Standing Order Act as well as from the point of view of Industrial Dispute Act. And how the FTC will take off? One is the salary and benefits as provided to permanent employees. The FTC employees are also entitled to get the equal to permanent employee when we are appointing to the particular post, and the benefits that are linked to continuous service, and the protection under the retrenchment. See, when I am relieving a person before a year of period of closing their employment period, then I have to comply under the Industrial Dispute Act. And in Indian courts, deemed a fixed term contract illegal if the contract was for continuous business activity. I am engaging a person for continuous period till his retirement. That is Kamala's contract. And the work did not have any fixed purpose. See, in some of the automobile industry or electronic industry, they may have the specific product manufacturing period. After that, the model will be closed. Then those period we can engage the fixed term period, fixed term employees. But it should not be the permanent nature. The contract was repetitively renewed with or without the notional breaks. So, forever we should not engage the fixed term employees. If at all need arises and engaging them for certain breaks and all, but it should not be the shadow breaks. That is what the Act says. There are so many case laws says it should not be the shadow contract. And in case where an employee was appointed for a fixed term same position repetitively with the notional break in between the consecutive appointments, court observed that FTC arrangement was devised to circumvent the benefit of permanence and therefore practice was illegal. So in this case, Chief Administrator Haryana Urban Development Authority versus individual, in this case very clearly said that in the Punjab Haryana High Court judgment, if we engage the permanent employee, in the place of permanent employee, we are engaging the FTC employee for to deprive the benefits to the FTC employee, that is Kamal's contract as per the court judgment of Punjab Haryana High Court. In the case of Ram Prasad versus State of Rajasthan, in this case, court found that the bad faith, since it is found gaps between the successive fixed term appointments to be artificial break redundant to prevent the permanent employee relationship. When we are engaging continuously, but we are giving the notional breaks for the fixed term employee, that is illegal in this case. FTC whose employment terminates on the expiry of the term is not subject to be or protected by the retrenchment obligation and the right provided under the Industrial Dispute Act, Section 200 BV, with the Section 25F IDA. So, we should give the appropriate relief given under the Industrial Dispute Act when we terminate the contract of fixed term employee abruptly or something like that. Fair treatment of fixed term employees in terms of benefit applicable to fixed term according to the model surrounding it. Benefits to fixed term employee. Fixed term employees are eligible for all statutory benefits. These benefits will be available proportionately according to the period of service rendered by the worker, even if the employment doesn't extend to a qualified period of employment. So he is also entitled for that. And the hours of work, wages, allowances, other benefits are not be lesser than that permanent employee. So that is very clear here. And how the FTC contract it should be. The justification is there for engaging on employee and the location where we are engaging and the period and the compensation and other terms and clauses like intellectual property, confidentiality, termination provision including can be terminated a yearly notice period or something like that, and the FCT number of lengths successive FTC, all these things to be defined in their appointment order when the time of engaging those employees. However, FTC are meant to be adopted only for temporary assignments. There is no legal restriction with respect to renewal of FTC. So there is no restriction upon this. The FTC doesn't need to explicitly state right or option of renewal. And the FTC can be renewed automatically provided that contract provides for the same specific circumstances in which FCC would extend automatically. And how we can terminate on FTC employee? If we want to close the fixed time employment prior to the conclusion of the period defined in his appointment, so we have to comply under the Industrial Dispute Act or in the appointment order. Whatever we said, we have to comply, or else it will automatically conclude after the period of interested in the appointment order as per the agreement. So, which includes notice requirement or payment in lieu, payment of retracement compensation, notification to the labor authorities requirement, payment of leave encashment, and also we have to comply under the ID Act. That is, last come first go principle to be adopted also at here when the time of terminating the fixed term employee before the period. So, when a person works for 240 days, even the FDC, we have to comply under the Industrial Dispute Act. And if the FTC is voluntarily he is going out of our service, there may be additional requirement to pay service compensation certain that is some of the states they are interesting so many obligation posting upon the employer. So that is available in some of the states. There are some case laws also under this. Grand Kakadiya Sheraton Hotel versus Srinivasa Resorts Limited, where Indian courts have considered Section 47 of Telangana's option have unconstitutional. They are saying, see some of the following labor laws which are applicable to the FTC also. That is equal remuneration, Industrial Standing Order Act, Building and Other Construction Workers Act, Minimum Wages Act, Maternity Benefit, Trade Union, Payment of Gratuity, Payment of Wages, Payment of Bonus, ESI, Provident Fund, and they are also comes under the sexual harassment of workplaces. All these laws which are applicable for FTC also, and some of the case laws in one of the case laws, that is in Airport Authority of India, merely because of the loaders were handling the cargo under the supervision of the International Authority, where such control and supervision is inevitable, contract labor don't become an employee of International Airport Authority of India. So here some of the contract which are privileged for supervision and all they are saying, that is not the rule of law. Test for determination of longer duration of contract. The object of giving the temporary employment only because of employee has been engaged either casual or temporary intermittently for number of years. So determination question unfair labor practice is essentially a question of fact. See here some of the employer may give the break notionally and engage them again and again, again and again, again and again. That is unfair labor practice. But the employer and the employee appointing them as a FTC, and they very well aware of that, for the project entrusted upon him for the completion of the project for ever, then that is not the cumulative contract for the appointment of FTC. That is very well said in Gangadhar Pillai versus Siemens India Limited. And also they are entitled for gratuity when the time of termination. That is very well said in the Karnataka High Court. Liability to pay the gratuity can be fastened on the principal if the contract fails to pay the same, and the Madras High Court judgment in 2013. This is what I want to say about the fixed time employee under the Indian context. So we can engage the fixed time employees as per the Indian law, but we have to comply under the all the laws which are available in India, that is Equal Remuneration Acts, Maternity Benefit Act, and the Factories Act, and all the laws which are applicable for them also. But the contract interested between the fixed time employee and the employer, well said in the contract, and it should not be the notional contract. All the benefits should be extended to the fixed time employee also. There is no restriction to engage the fixed term employee, and it should be project based or seasonal based, or the some of the assignment based. We can engage the fixed term employee. That is what I want to say today about the fixed term employment subject, and request you to subscribe to Murali HR for some more very good subject will come over in the further period. Thank you. I will meet you once again. Thank you once.